Good morning, everybody, and welcome back to the Law and Crime Network. I'm your host, Jesse Weber, and thanks for joining us today. We actually have a very, very busy day full of special segments and cases we've been covering, and you're not going to want to miss anything, so I want to break it down for you today. What we're going to play for you throughout the day, and what we did a little bit yesterday as well, is we're going to recap the Quinton Tellis case. This is the case of Jessica Chambers, that 19-year-old girl who was burned alive. The reason we are replaying that case, which, as you know, for anybody who was following it, that ended in a mistrial, that Quinton Tellis was found neither not guilty or guilty. The jury was split, couldn't figure out which way to go. We are replaying that whole case because in our new year here in our Law and Crime brand new studio, we believe that Quinton Tellis will be retried in Mississippi in connection with this young girl's death. So we want to replay that case for you throughout the day, and we'll talk about it as well. But we have a lot of special segments as well that we don't want you to miss. This morning, we're going to talk about a lawsuit that was filed against a university, a sorority, and hosts of a party who are being claimed that they are liable in a student's death. A young boy, a 19-year-old, a sophomore, who died as a result of being intoxicated and being hit fatally by a car. And we're going to talk about whether or not a university and all these different defendants are actually liable, because that, if so, that would be a big impact moving forward, not only in terms of college campuses, but anybody, any hosts of parties. So you're not going to want to miss that. We're also going to talk about this really disturbing situation about a new lawsuit filed by a mother of a disabled young girl against the school district because there were teachers who were heard in a voicemail mocking the disabled girl. I'm not making this up. I'm not making this up. I wish that I was, but it's the truth. You can hear it. We've been talking about this case. It's really, really disturbing, and now there's a lawsuit filed against the school district saying they didn't do enough when this came to light. We'll talk about that as well. Finally, this morning, we're going to be talking about we're also going to provide you any information about what we know so far, and hopefully anybody who's watching this, if you have more information, you can contact a special number to talk about it. So we're going to talk about that case as well. I do want to let our viewers know that at around 10:30 a.m. Eastern Standard Time, there is going to be an update in a case out of Arizona, which we briefly covered. This is the case of Thomas Robinson. Right before our winter break, you might have heard about this. This is about a municipal court judge, Thomas Robinson, who was arrested on suspicion of domestic violence and tampering with evidence. A judge. I know, I can't believe it. I can't believe I'm saying this, but it's true. Robinson told police detectives that he stabbed his wife 10 times on August 25th at their home in Chandler, and later threw bloody bed sheets and a knife in a trash bin. Now, originally, his wife and Robinson told police that an intruder had stabbed her. But that didn't last long. She called back the police and said that he was actually the suspect. What we expect today is a pretrial hearing. We'll dissect that case as well. It's too unbelievable to even say, a judge getting involved in this mess. We'll talk about that later. And then later on in the day, we're going to be talking about the sports betting case out of New Jersey. We're going to talk about singer Erykah Badu getting pulled over by police officers so they could say hi. We're going to be talking about the Yvonne Cordes case as well. Then we're going to be continuing our live coverage of the Brevard County Bond Court. Again, when people are arrested, they're brought into court for a bond hearing. It can get pretty interesting. We're going to play you a live feed of that later on in the day. And then finally, we are going to conclude our day by talking about the new law in California about marijuana legalization. So it's a day full of all law, all special segments, all important things to discuss, but I want to start our day by talking about this lawsuit against this university, the sorority, and the party hosts. And who better to help me talk about this than Law and Crime's own senior editor and former prosecutor, Ronn Blitzer. Ron, great to see you here.
Good morning. Great to be here on our new set.
Is this your first time on the new set?
My first time in the new set in the new year.
Looks pretty good, right?
I love it. It's great.
Well, they did a great job with it. So I do want to talk about this case. And what we know is that shortly after midnight on October 18th, 2013, 19-year-old Ethan Connolly, a sophomore at the University of Delaware, was fatally hit by a truck while walking across Delaware 896. Now, earlier he had attended an off-campus sorority, remember, off-campus sorority party, and toxicology reports indicate that his blood alcohol content was 3 times the legal limit. His parents have filed a lawsuit claiming that the university, the sorority, and those that hosted the party are all liable for Ethan's death. Now, Ron, I want to break this down. What's their theory here? I mean, I break this, I'm not sure I completely understand it. How can they all be responsible? How are they all claiming they're responsible?
Well, if you ask me, they can't all be responsible here. This is a tragic case of a student who died. He was, 19 years old, and it's a horrible accident. And now the family is just trying to hold someone accountable when they may not even be the right people. You know, you have the school, you have the sorority, you have the people involved in this party, but in order for them to really be liable, this sort of thing would have to be foreseeable. There would have to be actual negligence on their part.
So negligence, that's what they're saying. They're saying you're negligent, you had a duty to protect our son, you didn't do it.
Yeah.
But how is it their responsibility? How is it the university's responsibility? Let's break it down from them.
Right, so as far as the university is concerned, I personally don't think they're responsible for this. This was yes, he was a college student, it was a sorority party, they're affiliated with the university, but this was an off-campus party. The university officials aren't there, they're not endorsing this. They may have their rules about underage drinking, but so does the state. It's illegal. So the child, he was 19, but the student made these decisions to drink when he wasn't supposed to. Anyone who was organizing the party was not university related. This was an independent party held off campus. The university shouldn't be held responsible for this, as tragic as it was.
And there's a motion for a pre-trial judgment where the university and the defendants are saying, look, this is a guy who took matters into his own hands. He drank, and it's not even entirely clear, correct me if I'm wrong, Ron, that he got drunk at this party. Isn't it, there's some reports that he might have gotten intoxicated before the party?
Yes, and there's so much going on in this case that you really have to break down. I wouldn't be surprised if law professors in torts classes had something like this on an exam, because you have to remember, he didn't die from alcohol poisoning either. He was hit by a truck. I want to know more about what happened there.
Well,
did the truck driver...
He got dismissed.
So if the truck driver did something wrong, and say the driver should have seen him coming, whether or not he was in a crosswalk, if the driver should have seen it, and maybe the driver was doing something he shouldn't have been doing, you can't pin that on the university just because the kid had a couple drinks.
Wasn't he not walking in the crosswalk?
Right.
So it indicates that he was maybe intoxicated, wasn't walking in the right area.
Right, but we live in New York City. People cross the street, in the middle of the road.
Ronn Blitzer, you jaywalk?
I'm not saying I do it, but it happens. I've seen it a lot, from my experience.
You know a guy who knows a guy.
Yeah, I know a guy who knows a guy who's jaywalked a couple times. I'm not proud of it, but it happens. That doesn't mean that cars are free to just hit everyone walking if they're not in a crosswalk. You still have to be careful. You still have to take proper duty to not hit pedestrians even if they're not in the crosswalk.
Now let me ask you this. The sorority bussed these people to this event. Isn't it their responsibility to make sure everyone gets home safe? So if this guy walks off on his own, everybody that they brought to an event, again, it was an off-campus party, isn't their responsibility and the people that managed this whole event to make sure he got home safe?
Absolutely not. They are going above and beyond to even have transportation available in the first place. They're doing a great job. They know that some people drink a little bit too much and shouldn't be driving themselves. They're providing transportation to people who are going there. That's great on them. But it's not up to them to physically make sure each attendant is then getting back on the bus to go home. Now that, absolutely not.
This seems a lot like those dram shop laws where you hold bars liable for the actions of drunken patrons. Can you equate a bar with a sorority house, a fraternity house, college parties? Is that fair to equate those two? Because that seems what's happening here.
Yeah, I mean, it's definitely a fair comparison here. This was held at an off-campus facility. I understand that caterers are being sued here. If you have professional caterers who are serving here, maybe you could have an argument that they should know better not to serve underage people, and that they should know if an attendant has had a little bit too much to drink to not serve them anymore. But you can only pin that on them if the person being served is showing signs that they're overly intoxicated. We don't know what this student looked like at the time. Also, as you mentioned before, we don't know when he had all these drinks. If he had done 5 shots of tequila before getting to this party and then maybe had a glass of wine while there, no one's going to know that he's not with it.
But isn't the opposite argument, he's not 21 years old, he's underage. So the Plumbers and Pipe Fitters Local 74, which is a local union that owns the building, they provided security as well as bartenders. Capozzoli Catering served food at the party. Both are named as defendants, and the argument is that these defendants negligently failed to prevent underage drinking at the party. It's not like he was a regular, an adult who, he had too much to drink and we should have stopped him. He should never have even been around alcohol or even near it at the point. Isn't that fair to say from their filings? These are trained employees. They should know this.
Well, I want to know a little bit more about, and to be fair, I don't know about the procedures that they had for letting people into the party. Were they checking IDs? Did the student have a fake ID? I don't know. I think a lot hinges on that. If he had a fake ID that looked credible, then that's not necessarily on the people working security. If he didn't have a fake ID and he just went in and they didn't check, that could be something different. It's one thing, you can have a party where people under 21 are allowed in but can't drink. There are plenty of ways to monitor that. So if they didn't do that, that could be an issue. But again, that's not the university. So there's some people who arguably could be held accountable for this, but the school, I don't think so.
But here's my question. There has to be something to their case, because this lawsuit survived a motion to dismiss, and it's scheduled for trial next year. Doesn't that tell you that there is at least some merit to what they're saying here, that at least something about these defendants, that they failed to act in a reasonable way?
I think there's something to the idea that there's more that we need to know.
Okay.
We need to know more about all the different aspects of this case. If there was no question about the facts of the matter and the judge decided, well, no matter what happened, no one should be held liable here, then it would be dismissed. But the fact that they're moving forward with this case shows that there is an issue of fact here. What precautions were taken, if any? What condition was the boy in? Where was he crossing the street? What were the lighting conditions like? What was the driver's condition like? Who was really responsible for this? Was it the university? Was it the caterer? Was it the student himself? Was it the driver? There's a lot that we need to figure out.
If this case does go to trial and the plaintiffs are successful against these defendants, how does a university, how do fraternal organizations or sororities, how do anybody who's throwing a party, how do they react to this ruling? What happens?
They're terrified, because if I'm running a university and you're saying that I am responsible for anything that happens off campus, I'm shaking in my boots. How do you monitor these things? You have students, and how far off campus do you take this? If someone is commuting from the next town over and they're having a house party and people are drinking, is a university responsible? They shouldn't be. But depending on how this goes, maybe they would be.
It's interesting because everybody knows underage kids drink in college. I mean, it's
you know
ridiculous.
A guy who knows a guy.
I mean, I know the whole country.
Yeah.
It's ridiculous to say that won't happen, but I think it becomes an interesting perspective about when does someone have the responsibility to drink themselves and they're responsible for what they do, or is it the university's responsibility? Because isn't it a way to say, if you're a parent, I've given my child to the university, okay? It's their job to protect my child when they go to school there. It's my job to know, it's their job to make sure that they are bused correctly to campus or off campus. And I think that becomes an interesting perspective to say, what is that realm of responsibility? Because everybody knows this goes on. I mean, I want to read something to you. some cases that happened. Brett Griffin, 18 years old, died of alcohol poisoning, in November of 2008 after a night of drinking at Sigma Alpha Mu Big Brother party. His parents filed a wrongful death lawsuit against the national fraternity and several members, and it was settled before trial with all but 2 former chapter officials who were later cleared of liability in his death. Then in 2016, a 20-year-old student visiting from another school fell to his death from the roof of an unofficial fraternity house, and the death revealed difficulties for officials seeking to police parties off campus. So what I'm saying here is, you keep seeing these incidents. When does it become an issue of the fraternity's responsibility, the university's responsibility, or the child's responsibility? And I say child because they're underage.
Yeah, so I think most importantly, you have to remember that this student acted of his own free will as far as we know. If someone snuck something into his drink and he didn't know, that's a different story, but then that person would be responsible. As far as holding schools accountable for this, if someone dies as a direct result of their alcohol intake, if it was alcohol poisoning or something related to that, and this happened on campus in an official school facility, then yes, hold the university accountable, because they should be, because they hosted this event where this tragic thing happened. That's not what happened here. This was off campus, and he didn't die as a direct result of the alcohol. He was walking down the street, he was crossing the street where he shouldn't have been, and was hit by a truck. Not by the university, by a truck. So there's so many other steps here. I go back to what I said before about this being foreseeable. Would the university foresee that by letting an organization hold an event off campus that someone would be hit by a truck? There are a lot of steps in between.
This has taken, I think, 3 years for attorneys to get all the depositions and all the evidence, and you can just try to see what kind of arguments are being made. And if you're the defendants, you're going to say either A, he got drunk before he came to the party, B, like you said, it was not foreseeable, or C, maybe some people are responsible, but not every defendant the caterer can't be responsible for this. So I think it's going to be an interesting case to follow and see, because it does provide an interesting context for social events and college parties moving forward. So we'll have to see what happens. But Ron, I do want your thoughts as I want to play a clip right now for the Thomas Robinson hearing. Again, we're going to play you something. This has happened a couple of weeks ago when Mr. Robinson came into court. Just your initial impressions here. A judge? Shouldn't this guy know better? And again, we don't know all the facts, but a judge?
Yeah, I've appeared in front of a number of judges, so they're people too, so you try to hold judges to a higher standard,
yeah.
And we should, but these are humans, so they're gonna do things that anyone else might do.
Well, I hope not everybody is accused of stabbing their wife 10 times, but we'll have to see. I want to play for you right now when Mr. Robinson made his court appearance several weeks ago. And again, we do expect a pre-trial hearing at around 10:30 a.m. Eastern Standard Time. As soon as we have it, we'll make sure to play it for you. But here is a clip from a couple weeks ago.
This is State of Arizona versus Thomas Jeffrey Robinson, 2017, 143703. Appearances today.
Good morning, Your Honor. Robert Beardsley for the state.
Judge, I'm Thomas Robinson. I'm the defendant. Date of birth, March 4, 1962. My attorney, Mr. Contreras, present as well. I'm speaking because his voice isn't doing very well today.
All right.
So he's filed a motion to continue, requesting 2 weeks, and we would agree to exclude time.
A 2-week continuance of the pretrial conference. Yes. State have any position?
Your Honor, this is the first I'm hearing of it. I have no objection to continuing the CPTC for 2 weeks.
Wednesday the 3rd works.
Wednesday the 3rd? All right. That would allow defense counsel to speak, probably, which would be helpful. So we'll continue the comprehensive pretrial conference to Wednesday, January 3rd. At 8:30 on the morning calendar, just like today. Right now, the trial date is set for March 1st. That's affirmed at this time. We have a couple, I guess one matter that was filed, and that was a request to travel. I think there's a minute entry in process that grants that. The question, does the state have any input at this point?
Yes, Your Honor, the state would like to make a record regarding that motion to allow travel out of state. The motion was electronically filed, as I can see, on December 1st of 2017. However, a copy was never sent to the state until your court emailed a copy on December 4th at about 3 o'clock. The address addressed to the Maricopa County Attorney's Office is for 201 West Jefferson. That's the court. It actually says the East Court building. My address is 301 West Jefferson, the 5th floor. I'd also ask to be endorsed electronically via email with any motions filed in the future. Given that I didn't receive notice of this filing until December 4th, I was unable to comply with victims' rights any faster than we did. I had a meeting yesterday with the victim. She is opposed to the out-of-state travel for a number of reasons. She believes that the out-of-state travel is being used for an opportunity to provide the defendant an opportunity to move funds around and also to avoid prosecution. The state takes no position on the motion to travel, but I have an obligation to make the victim's position known.
I appreciate that. There will be a minute entry granting the motion to travel. I think the defendant is right now OR, I believe. So for the days that were described in the motion?
$50,000 bond and also court services. I have electronic monitoring too.
Okay. Thank you. The motion is granted. There will be a separate minute entry. I appreciate the victim's rights compliance. And we'll be back on January 3rd then.
Okay. Actually, for the record, I can avow no movement of funds, and I'm coming back.
Thank you. Is there a family court case going on?
No,
No, Your Honor.
not just this.
Not that I'm aware of.
All right.
Okay.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. You were watching a replay in the Thomas Robinson case out of Arizona. We believe at around 10:30 a.m. today, Eastern Standard Time, there will be a pretrial hearing in the case of this municipal court judge who has been arrested on suspicion of domestic violence and tampering with evidence. This is all stems from when he had told police detectives that he stabbed his wife 10 times on August 25th. Originally, his wife and himself had told police that an intruder had stabbed her, but Mrs. Robinson had called police and said that she was the one who actually had stabbed her. And now this man faces some pretty tough charges, and it's going to be very interesting whether this does go to trial or not. We'll hear more about it today at that pretrial hearing. I want to talk now about another special segment we're going to cover today. This is out of Pennsylvania. A Pennsylvania mother, Beth Suhan, filed a federal lawsuit against the McGuffet School District for allegedly discriminating against her daughter, who's now in 8th grade. Her young daughter has what's known as Turner syndrome, a chromosomal condition in women that causes developmental problems and learning disabilities. Now, what happened? Well, she claims that in 2015, the daughter's 5th grade math teacher left a message on her answering machine. But she forgot to hang up. The teacher forgot to hang up, recording himself and 2 other educators mocking the girl and another disabled student. In fact, what can be heard is saying that her teeth are crooked. They suggested that the young girl has no strengths. And one educator said that she could coal mine, she could be a good coal miner. This is really, really disturbing things in these allegations against these teachers, that these teachers might have said these things. The lawsuit said that the school district, did nothing about this. The mom is also suing the district under another theory. She's saying that the school district canceled a special needs education program for her daughter in 2013 without telling her. And this resulted in what she claims are years of delays in the girl's education. This mother is suing under a variety of different theories. In her federal complaint, there are claims of retaliation, violations of the Rehabilitation, Americans with Disabilities, and Individuals with Disabilities in Education Improvement Acts, denial of her daughter's constitutional right to an education, along with just a general discrimination claim. And she is seeking damages against the district. I'm here today joined by Ronn Blitzer, senior editor at Law&Crime Network and former prosecutor, Ron, these are some pretty serious allegations let alone against teachers of a disabled student. What do you make of this?
It's disturbing to hear that teachers could say such a thing about a disabled child. Children who are different from other kids often get bullied by their peers, but you'd think that the faculty wouldn't join in on it. You'd think that the care of the teachers would be, a safe space, if you will. Parents are entrusting the care of their child to these teachers, and they're just as bad as kids might be in poking fun. But as horrible as that is, that alone might not be enough to win a lawsuit. However, it is significant evidence, in my opinion, that the school and the district just don't care about this girl's education or well-being. So when you talk about how the program for this child was canceled without anything being done about it, and now you have teachers who are saying horrible things about a disabled student and the school doesn't do anything about it, then that just builds a case that this school is exhibiting indifference at best and possibly negligence or just going out of their way to do this girl harm.
Doesn't one of the teachers still work at the school?
I believe so, and that's unfathomable to think that a teacher who could display such gross behavior would not face significant discipline.
What's brought up in this case, and I think is a great point, this young girl can't defend herself. She can't report that her program was canceled. She couldn't report that there was abuse. I mean, she suffers from a serious condition here. And I think that's what makes it so terrible to hear is the vulnerability of this young girl. She's not like every other child, when something happens, she can report about it.
Yeah, and what are the parents supposed to do here? So they pull her out of school, for a number of years, and they put her back, hoping different teachers might be a little bit different, things might be better. But this is a public school district. It's not like you have multiple options for choices of schools. You either do this or you homeschool, or there's not a lot for this family to do. And it is the school's duty. This is public schools, this is a government agency. The government should be taking care of its citizens, and they're not doing a good job here.
And I know the parents had to bring her out of school, bring her onto online classes, and now she's back at the school.
Yeah.
This young girl is back at the school. There's only so much you can do for a child's education. At the end of the day, what's best for the child, and if an education at the school is better than online classes, but look what she has to go through.
Yeah, I wouldn't trust the school district if I was a parent. Again, assuming that these allegations are true, you have to, couch that and say these are still allegations. Nothing has been decided one way or another, but it certainly looks bad.
Yeah, it does look bad. I thought it was very colorful for the attorney in this case, Noah Geary. He is representing this mother. He said that one of the teachers tries to reason with me about the comments in the recording when they spoke over the phone. Her response to me was, "Have you ever had one of those days?" That was her reasoning for making hideous remarks about my child and another special needs child. That was what the mother had said. Now, if this is true, that have you ever had one of these days? If this is actually true, what the teacher had said to this young girl's parents, what is that?
If this was the only incident, if the only complaint against the school and the school district was that one teacher said one thing, not realizing that they were being recorded on the voicemail, I might be understanding enough to say, that was terrible and you really shouldn't say that, but is it worthy of a lawsuit? Not necessarily. But when this is just another example of the school and the school district treating this poor student like something less than other students, that's a big problem. And that's, just saying one of those days doesn't cut it for me.
Well, what do you think about these actual allegations, these actual charges that were, not charges, but these claims that were brought in this complaint? We're talking about retaliation, violation of several different acts, including acts about disabilities, denial of her daughter's constitutional right to an education, discrimination. What do you make of those exact claims put forward in the complaint?
There's a case for some. Some claims have stronger cases than others, in my opinion. Discrimination, if the school is, if they should have been providing this program that they were providing and now they're not, and then as a result of the family, complaining about this, if the student is being subjected to certain treatment by the teachers, that could be.
Let me ask you this. I'm sorry to interrupt. This is just, I thought about this. If these teachers have had a pattern of mocking all different kinds of children, disabled, not disabled, boys, girls, everybody, doesn't really matter. They don't discriminate against who they discriminate. Does that kind of weaken that claim?
It would weaken a discrimination claim, but it would certainly open up a whole new one because who does that? That would be pretty terrible. I mean, lighthearted ribbing is one thing. I had teachers that would make fun of all of us, and it was all fine and good. But if you're making fun of individuals based on their identity or based on certain handicaps that they have or disabilities, no matter what, even if it's everyone, that would be horrible.
Yeah, I think the denial of your daughter's constitutional right to an education, that's pretty strong. And you have to see it because usually when you see in these cases, making comments or canceling a child's program, you're directly interfering with a child's ability to learn. And I kind of understand how that's going. I do think it's interesting how there has been some developments in this case in terms of there was a due process complaint that was decided in September of this past year. Michael McElliott, a special education's hearing officer, found the school district, had discriminated against this girl. So that was already determined in a due process complaint by the school. And he said, anyone listening to the voicemail recording would agree, it is nearly unfathomable and frankly heartbreaking to gauge that the speakers on that recording are educators working with 10-year-old children and are particularly discussing some of those children who clearly have significant disabilities. So the fact that they were already found responsible for this due process complaint brought by a hearing officer, what do you think about that?
I agree that it's unfathomable, that it's heartbreaking. But the more I think about it, as far as discrimination, I would like to know more about what's going on, what went on inside the classroom, because the comments were not made to the student, at least the ones that we're talking about. They weren't even made to the parents. They were just made on the voicemail and supposedly by mistake. So what's the actual discrimination here? Now, I'm on board with discrimination potentially by the school for canceling this program and not affording this child proper education and not even giving the family proper notice that they're canceling this program, if those allegations are correct. But just horrible comments aren't necessarily discriminatory. So if they were making comments in the classroom as well, or if they were not properly treating the student and catering to her needs or really educating her because of her disability, that would be a stronger case for discrimination. So I want to know more about that.
But even comments, if they never canceled the program, comments like her teeth are crooked, she has no strength, she could be a coal miner. I mean, these are cruel comments. If the daughter knew about these comments, or the mother knew about these, obviously the mother knows about these comments, isn't that discriminatory in its effect in general? Because now this girl has to go back to school with this understanding that this happened and that her teachers think of her this way. Isn't that enough? I mean, just these statements, or do you really need something more? Do you really need that pattern?
For me personally, I'd like to see a stronger case. I'd like to see some more evidence. But yeah, you do make a good point. If the student hears about these comments, how does she react? How does she go back to school and get on with her education, as insufficient as it might already be, knowing how her own teachers feel about her? Yeah, that is a good point. But to get a strong discrimination case, I'd like to see a little bit more.
I think I'm just happy that that phone kept recording, because I think it was important to hear about this. And again, it's allegedly that they were making this. As you said, we still have to hear the facts. But in today's day and age, this thing can capture a lot. And I think it's very interesting to see. You know what I mean? I mean, people don't, the lack of privacy or what they are able to keep secret is not anymore because of this.
Yeah, no, we can argue whether or not these allegations make up enough for these claims in the lawsuit, but even if they're not, it's still ridiculous. It's still heartbreaking. This shouldn't be happening, and you'd like to see at least some sort of discipline.
Yeah, I agree with you. Ron, stand by. We have another case to talk about. An alleged, not even alleged, two girls are missing, a 7-year-old and a 14-year-old out of Texas, and we believe they are kidnapped. We're going to talk more about that in a minute. I do want to play for you right now a clip from Quinton Tellis, the Quinton Tellis case. This is important because this case, the reason we're talking about it is we believe that in 2018, Quinton Tellis will be retried for the murder of 19-year-old Jessica Chambers, that young girl who was, it's so hard to talk about, she was burned alive. And what you heard yesterday when we were replaying it was the testimony of first responders who saw Jessica Chambers coming from the woods, and they described what they saw. She looked like a zombie, and she had burns to, I believe, 93% of her body. And they choked up on the stand. You heard the way that they were talking about her. Really, really, really tough to hear. We played the beginning part of that. I want to continue playing you testimony from this case. And when we come back, we're going to talk about that case as well as this, this horrific situation out in Texas. So here's the clip from Jessica Chambers. And when we come back, we'll be back with more analysis.
This lady does a good job. I'm telling you, you may pick up a few pounds while you're up here on this little jury duty we have. I hate to ask you this again, but I must. You all have followed my instructions and not discussed the case among yourselves. All right, very good. May call you next witness, sir. Bradley Dixon.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
State your name for the record, please.
Bradley Dixon.
All right, Mr. Dixon, I'm going to ask you to speak up so everybody can hear you, okay?
Yep.
Where are you currently employed?
Pafford EMS in Tate County.
In Tate County is just to the north of here, correct?
Yes, sir.
And on December the 6th of 2014, where were you employed?
MedStat here in Batesville.
Were you doing the same, do you have the same responsibility for MedStat that you have now for Pafford?
Yes, sir.
And what was that responsibility?
I was the EMT of the ambulance.
And just so the jury's aware, what is the EMT of the ambulance? What are your job duties?
Assist the paramedic in his roles and responsibilities, handle certain things. I can do basic medical skills, but not as much as a paramedic. He's the primary care provider on the ambulance.
And are you also the driver?
Yes, sir.
So on December 6, 2014, were you the EMT that responded to Heron Road?
Yes, sir.
And who was the paramedic on board with you?
Josh Perkins.
And I believe a run report was done for MedStat, is that correct?
Yes, sir.
Who prepared that report for MedStat?
Josh did.
Okay, so you did not prepare a report, Josh prepares it for you?
Correct.
I'm going to ask you, when you arrived on the scene at Heron Road, tell the jury what you saw as you were coming in.
So, of course, there's going to be fire trucks there. There was a few fire trucks there. A couple personal vehicles. I guess first responders showed up in their own vehicles.
Is that typical?
Yeah, on certain calls, especially far out in the county.
What was this particular call in reference to?
We got the call as a car fire and a possible burn patient.
All right, go ahead.
So when we pulled up on scene, I parked beside one of the fire engines. I didn't, when I arrive on scene, I try to look for possible patients. I don't pay attention to, outside. That's not my responsibilities to pay attention to, such as a car fire. So I didn't notice that right away. When I got out, I saw a couple firemen behind the fire engine kneel down beside what turned out to be the patient.
When you saw the patient, what was your first thought?
That we needed a helicopter.
Why was that?
Helicopter is used for severe patients. Since we're in a rural area, helicopter gets them to where they need to be quicker than what we can.
Describe her condition to the jury as you saw it.
When I first laid eyes on her, her condition was very poor. She was burned from the parts of her body that I saw first was completely burned. I didn't notice any part of her body that wasn't burned.
Describe the area of her mouth.
Her lips were real leathery, almost charred. Her face was third-degree burns. Eyelashes were gone. Eyebrows were gone. Her hair was a singed mass.
When you said you knew immediately you needed a helicopter, who do you relay that information to?
I relay it to my partner, Josh, make sure that's, because ultimately it's his decision.
Who got to look at her first, you or Josh?
I don't recall.
Now, did Josh ultimately call for the helicopter?
He told me that he is okay with that decision, so then I went to the ambulance to get on the radio to tell our dispatch to call the helicopter.
Well, let me ask you about, everybody's got their roles, correct?
Yes, sir.
Your particular role as the EMT is to assist the paramedic, is that
Correct.
And I assume normally you can do that on the ground with the patient?
Yes, sir.
In this particular case, was there another person out there that could also assist in that manner?
It was.
Who was that?
Casey Austin,
And what is Casey Austin to your knowledge?
paramedic.
So we have another paramedic out there for help.
Correct.
At some point, did Casey help Josh? Did Casey assist Josh with the body?
Yes, sir.
And where did you go?
When I went to call for the helicopter, I got into the back of the ambulance and started getting a sterile burn sheet to take to my partner, and also to prepare for when the patient was brought to the back of the ambulance.
So you stayed in the ambulance.
After I took the sterile burn sheet to my partner and then went back to the ambulance to start preparing for the patient's arrival.
When you have a burn victim, what do you do inside the ambulance?
Normally, we have to start IVs, keep the patient very warm. The sterile burn sheets are used to limit infection risk and provide oxygen.
Did you do anything to the temperature controls inside the vehicle?
I did. I turned the heat all the way up.
And tell us how that works in an ambulance. Is it different than a car?
It is. You have one dial that has numbers on it, 65 to 85, and you just pick the temperature that you want.
So the heat was running?
Yes, sir.
Did you ever get out of the ambulance to help them load
No, sir.
the lady in?
No, sir.
Okay. Tell us what you did once she was loaded into the ambulance.
Once she was loaded in, I turned the oxygen tank on, hooked up the oxygen mask, also handed Josh, my partner, the IV setup, the IV supplies that you need to start an IV with.
And did Casey also get in the ambulance with you?
Yes, sir.
So you had two paramedics inside the ambulance.
Correct.
Did anybody else, what I call poke their head in or come in the ambulance?
They did.
Who was that?
Daniel Cole,
And was Daniel trying to talk to the young lady?
he was.
What was he saying?
Asking her, who did this to you?
And you said she had her oxygen on, is that correct?
Correct.
Where were you sitting?
I was at the head of her.
Okay. Was she able to respond at all?
She was.
And what did you hear her say?
The first time she responded, couldn't hardly hear her because of the oxygen mask and all the noise that was in the ambulance. So we had to ask her a couple times. Daniel was poking his head through the door, and I was leaning down to talk to her in her ear, just relaying what he was asking.
Describe her voice at that point.
Raspy, you could tell it was dry. You could tell her mouth was burnt, trouble speaking.
So was she speaking like me and you are right now?
No, sir.
Did you have trouble understanding what she said?
Yes, sir.
Did you ask her to repeat herself several times?
I did.
Ultimately, I believe Josh put in his report, and you thought you heard a name, is that correct?
That's correct.
And what name did you believe you heard?
Eric.
Out of all the time y'all were in the ambulance, how many words do you think you were able to make out?
Maybe 3.
Outside of Eric, what were the other 2 words?
Thirsty and cold.
And in regards to her saying thirsty, was she able to enunciate that?
No, sir. You could make out that it was a 2-syllable word that sounded like thirsty, and I then asked her, "Are you saying you're thirsty?" And she acknowledged with a head up and down.
When you say thirsty, your tongue hits the top of your mouth, is that right?
Correct.
Was she struggling in that capacity?
Correct.
What did thirsty sound like to you?
Thirsty.
And what other word were you able to realize?
Cold.
Is that typical of a burn patient?
It is.
Your Honor, I tender the witness.
Cross.
Good afternoon, Mr. Dixon.
Good afternoon.
So you were the driver that day?
Correct.
Okay. And do you recall from memory what the at scene times were, what time you got to the patient who would have been Miss Jessica? Do you recall that from memory?
Not from memory. I had to look over.
Okay. Your Honor, may I approach the witness
You
to
may.
refresh his recollection? What does that appear to be to you that's before you?
Patient care report.
Okay. If you will, look sort of midway the page, and it talks about response times and mileage. You recognize that?
Yes, ma'am.
Okay. And if you will, what time does it appear that you arrived at the scene?
2029.
Okay. And so tell me what 2029 is.
8:29
That would be 8:20.
p.m.
Okay. PM. Okay. And the next thing would be, what time did you arrive at patient?
20:30 or 8:30 p.m.
8:30. Okay. Then the next time would be you departing, is that correct?
Correct.
Okay. What time would that be?
20:42 or 8:42 p.m.
Okay. And then it has arrival at destination. What would that be?
20:44 or 8:44 p.m.
Okay. So basically, you got there at scene about 8:29. A minute passed, correct? When you got to Miss Jessica, which would be 8:30.
Correct.
And then departed about 12 minutes after that, correct?
Correct.
And then looks like it was a little bit longer going from when you departed to probably the arrival at the church.
Correct.
Correct. And at the time that you were with Miss Jessica in the ambulance, you did hear her use the name Eric.
Correct.
Okay. I attended the witness, Your Honor.
Redirect.
Your Honor, he's already got the run report. Actually, it's going to be Josh Perkins' report. I would ask him to be offered and received into evidence.
Sure. No objection.
All right. Be so marked and admitted. That's 13, is that right?
No further questions, Your Honor. I would ask that Mr. Dixon be finally released.
Give me just a minute.
Sorry, Captain. That report is actually a report that's prepared by the paramedic Josh Perkins. Is that correct?
Correct.
Your Honor, no further questions. I would ask this witness be finally released.
All right. Sir, you're finally excused. You may leave the courtroom or you can stay. Your choice. Yes, sir. Let me call your next witness.
Josh Perkins.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
What is your name?
Joshua Perkins.
And where are you employed?
Currently lifeguard ambulance service here in Panola County.
And what position do you hold with them?
I'm a paramedic.
How long have you been a paramedic?
Since December 2010, so 7.5 years now.
So on December the 6th, 2014, you were a paramedic.
Correct.
And I don't believe at the time, it was a different ambulance service here in Panola County at the time, right?
Yes, sir, it was.
And who was that?
MedStat EMS.
Do you recall getting toned out to respond to an area on Heron Road?
Yes, sir, I do.
All right, do you remember where you were when you got the call?
We were at the Batesville station. It was called Station 9.
And where is that located?
I believe the address is it's Highway 51 North. I don't remember the actual numerics of this.
Actually, it's just right over here, isn't it?
Yes, sir, it's right over there.
Almost parallel over from this building over on Highway 51?
Yes, sir, it's across the road from the library.
Okay. These folks from Pike County, so they're not familiar with Panola County,
Yes,
but
sir.
as crow flies, it's less than half a mile from here, is that right?
Yes, sir.
Okay. When you got toned out, what was the nature of the tone that you received?
I believe it was a female with burns. There was not a very much specific information initially.
Okay. How does that work? Who actually calls you? Does the sheriff department call you, or do y'all have a dispatch that calls, or how does
Yes,
that
sir.
work?
At that point in time, you have your original 911 caller. I believe it went to Panola County Dispatch. Once they determined that an ambulance was needed, they forwarded it to MedStat's dispatch center in Winona, Mississippi.
Okay, and then your dispatch actually
Dispatch
calls
does.
and tells you what you got.
Yes, sir.
Once you leave and you're headed to the scene, do you make attempts to communicate with people or firefighters at the scene to give you updated information as you're going?
Yes, sir. Sometimes we do. We'll make that request to our dispatchers at MedStat, and they would call Panola dispatchers and gather what information they could.
Or were you able to gather any more information en route to Heron Road from right over here?
I do not recall anything specific.
Okay. Tell the jury what you found upon your arrival at our own Heron Road.
Okay. We pulled up to Heron Road. There was a volunteer firefighter pumper truck there on scene, several people around her. Jessica was wrapped up in blankets at the back of the fire truck as we pulled up. I was in the front passenger seat, had my partner in the driver's seat. The way we pulled up, he could see her out his window. He looked out the window and turned around, looked at me and said, "It's real," as it's real bad. So I got out of the truck, went over, laid eyes on her. Yeah, it's real bad. Called for a helicopter. There's no hospital anywhere near here that can treat her appropriately. So
Let me ask you this, if you don't mind stopping for a second, John. If you would pull that microphone down a little bit, talking to it. When you say it's real bad, what did you see about Jessica? Let me ask you this.
Well,
Did you know Jessica at the time?
no, sir.
Okay. And you learned her name subsequent to treating her, is that correct?
She didn't mention. She was able to tell us her name.
Okay.
While we were there, yes, sir.
I'll get to that in a minute then.
Okay.
All right. What about what you were observing of her on the ground made you think immediately that you needed a helicopter?
Well, I did notice there was burns, a significant amount of burns on her body. At the time, there was not much of any hair left on her head. Looking at pictures of her before and after, it's a significant difference. I thought it was somebody with a short haircut until I got her in the back of the truck in proper lighting. You can see how severe her hair was burned away. But there on the ground, I could see that she was burned significantly and needed to be somewhere else in a different hospital.
And where did you notice the majority of the burns to be?
Oh, well, they were pretty much head to toe on her body, sir. To be somewhere else in a different hospital.
And where did you notice the majority of the burns to be?
Oh, well, they were pretty much head to toe on her body, sir.
You generated a report.
I did.
As a result of this, I'm going to hand you what's been previously marked as Exhibit 13 and ask you to look at that and tell me if you can identify that.
This is the report I wrote.
Okay, Josh, if you would go to the page after your narrative. And there appear to be 4 drawings on that page.
Yes, sir.
Does that look familiar?
Yes, sir.
And there appear to be a large number of numbers. I think it goes up to 32, or no, excuse me, up to 42. Is that, or excuse me, 51.
51 is the highest I'm seeing, yes, sir.
And what does these drawings depict?
Well, if you'll continue on to the next page, you can see...
Welcome back to the Law&Crime Network, everybody. This is Jesse Weber, and thanks for joining us. We're playing replays in the Quinton Tellis case out of Mississippi. This is the death of the case of 19-year-old Jessica Chambers, who was brutally killed by being set on fire while she was alive. And what you're hearing is some of the testimony from first responders and people who were able to see Jessica right before she died. The reason we're playing this is because we believe in 2018 the retrial of Quinton Tellis will take place, because his first trial, which we're replaying for you right now, ended in a mistrial. And we're trying to understand why that happened, analyzing all of the testimony, and we'll talk about that in a minute. But what I want to focus on right now is some breaking news. I'm sure people have heard about this, and if you haven't heard about this, please do. It's very important. There is a story out of Round Rock, Texas. An Amber Alert has been sent out for 2 young missing girls. We're going to put their picture up on the screen for you. We have 14-year-old Lilianis Victoria Kate Griffith and 7-year-old Lulu Violeta Mariposa Bandera Margaret. These are the 2 missing girls right there. We want to keep the image of there so you can see what they look like. Lily is 5 feet, 100 pounds, with light brown hair, brown eyes, with a right nose stud and braces. Lulu, she's 4'5", 75 pounds, curly brown hair and brown eyes. Now, the other man you see on the screen right there, police are looking for him. His name is Terry Allen Miles, and we believe, and authorities believe, that he may have abducted these 2 girls. Now, he has been described as a man who is 6 feet. He is 200 pounds. He has brown hair, hazel eyes, wears glasses, and has a beard. It should be noted that the reason they believe that these 2 girls have been kidnapped is because their mother, Tanya Bates, was found dead in her home. And it is believed that Mr. Miles was the roommate of Miss Bates, and that is why he is wanted in connection both with her murder, with her death, and with the abduction of these 2 young girls. It is believed that the suspect is driving a gray 2017 Hyundai Ascent with a Texas license plate reading JGH 9845, and we believe he may be headed toward Louisiana. This is really a breaking case, so if anybody has any information, we want you to call 512-218-5515 or 911. Again, that's 512-218-5515 or call 911. I want to talk about what we know about this story and what developments we might be expecting down the road. I'm joined today by senior editor at Law&Crime.com, as well as former prosecutor Ronn Blitzer. Ron, really disturbing case. What have you heard about this so far?
Yeah, this is very upsetting. I hope that these children can be found unharmed, but we'll see what happens. I'm reading here, as of last night, that the gray sedan that Miles was said to be in was spotted in northern New Mexico. The car was reportedly registered to Bates and her boyfriend. But there is concern that Miles may have gotten rid of the car, or maybe going to California where he has family. You mentioned Louisiana. He does have history in Louisiana as well. He has a long criminal record, I'm reading, that goes back to Louisiana. Some of it is rather disturbing.
Leah, let's break that down. I've read that he's been arrested and charged with attempted second-degree murder. Is that what you read?
I didn't see that one, but I'm not surprised given some of the other things I've seen. I've seen that he's been arrested for burglary, theft, child pornography, multiple instances of domestic violence. There has been accounts from a woman saying that her niece had been in a relationship with Miles in the past and suffered horrible physical abuse. Really hope that authorities can catch this guy before serious harm comes to these girls.
Yeah, it's really disturbing. I read that he was reported in October of 2011 that he had been arrested and charged with attempted second-degree murder. He was accused of strangling his live-in girlfriend and hitting her with a blunt object. Really disturbing. It should also be noted that there was, I believe he might have children, and his Facebook page shows that he is a grandfather as his son is a father. And his son had actually told, had said that he's not my dad. I haven't seen him in 25 years. He stole those pictures off my wife's page. We are not friends. Facebook won't let me find him to unfriend him. I don't want any part of him or the situation he is in. Now, if that is from his son, that is some really, really heavy stuff to hear, talking about his own father. So you can imagine the danger that this man presents to the public and these young girls.
Yeah, fortunately, it looks like there are some leads, that the car has been spotted in certain areas. I really hope that this gets resolved sooner rather than later. With cases like this, the longer it goes, the tougher it could be to solve. But we've seen cases where young kids disappear and they are found, they are tracked down. Hopefully that'll happen here. How important is that Amber Alert? I mean, it was issued for connection with these two girls. It goes across the nation for anybody to find. And if you go on the Amber Alert Twitter page, there's constant updates about it as well. The Amber system, I think it was developed in 1996. It's really, really been a tremendous asset to find children that are missing. Yeah, it is a great service that we have to help these children who are in trouble. Gets the word out across the nation, and any more information that we could provide to people or that people can see and then report back to the media or to authorities is valuable. This way, anyone who's in the area or in surrounding states could keep an eye out and see what they can find to try to help solve this case. We don't know exactly the relationship between Mr. Miles and Tanya Bates, who was found dead. We believe they were roommates. It should be noted that there was a report that earlier in this December of 2017, so again, just happened, police had been called to a domestic disturbance at Bates's home. And apparently, police had knocked on the door of a neighbor, James Reed, and he said it's nothing that's going on with me. And apparently, it had something to going on with Miss Bates' house. And it's believed that perhaps Mr. Miles had a connection with Miss Bates in that manner, and perhaps was violent towards her. Again, we're speculating here, but we do know that he is a person of interest. How often do you see people who are either living together or have some sort of relationship, they're the main suspects in the disappearance of small children? Oh, it's pretty common for cases like this. And when I was still trying to get information about this when I was reading up on it, I assumed that it was someone close, because when you have the kidnapping of 2 children as well as the apparent murder of the mother, that is personal. That shows that there's a personal relationship between the perpetrator of this and the victims. This does not look like the case of a stranger snatching a kid at a mall. This is someone who knows the people involved. So that's why I think that the suspicion of Terry Miles is probably accurate.
We keep showing the picture of the 2 young girls and Terry Miles. How realistic is it to imagine that they might have changed their appearance, that he might have changed their appearance, he might have changed his appearance?
Yeah, that's something that you hear about in cases like this. As far as changing their appearance, it's certainly possible. I don't know how he would go about doing that. Maybe making them wear baseball caps to, so you can't see their hair. Dressing them differently. For him, some contact lenses and shaving the beard would do it. You really hope that this gets settled sooner than later.
I agree. Again, for anybody who has any information about this case, call 911 or 512-218-5515. I want to show those pictures one more time of these 3 individuals. We're looking at these 2 young girls, ages 7 and 14. We know that 14-year-old Lilianis Victoria Cake Griffith, again, her Lily, as she's been called, 5 foot, 100 pounds, light brown hair, brown eyes, with a right nose stud and braces. You see her there on the left. The young girl in the middle is 7-year-old Lulu Violeta Mariposa Bandera Margret. She is also known as Lulu. She is 4'5", 75 pounds, curly brown hair and brown eyes. And the man on the left is Terry Miles. He is the person of interest in this case, 200 pounds, 6'2", brown hair, hazel eyes, wears glasses and has a beard, although as Ron and I just said, there's always a possibility that they changed their appearance. We do wish the families to the best of luck in this search. We hope that these 2 young girls are found safe and sound, and hopefully there is a good resolution to this moving forward. And if we do have more information here on the Law and Crime Network, we'll make sure to we'll talk to you about it immediately. What I do want to focus on right now, however, is to focus back on the Quinton Tellis case. Ron and I are going to talk a little bit more about it after this short break, where we show you a little bit more of that testimony in the case, because Ron and I want to dissect, why did this end in a mistrial? What are we seeing right now, and what can we expect in 2018 as this case hopefully gets retried and there's some answer as to what exactly happened to Jessica Chambers. So in the meantime, here is some prior testimony from that trial.
Has a list, and the list what the site number is that corresponds with the pictures there. It lists which injury site it is. For example, number 1 is the upper extremity. It lists injury details. On this one, I put a burn char on the left bicep. If it's the way these are listed, you can, if it's a burn charring, as if it's listed as that, you can put it as a 3rd-degree burn. Burn blister would be a 2nd-degree burn on here, and I believe there's redness, which would be 1st degree. Yes,
so, Your Honor, should I just stand here and kind of publish this to the jury, what we're talking about, so they'll know?
Yes, sir, you may.
All right, so what I'm showing to the jury here is the diagrams or the locations of the burns that you noted as you were examining her and after you examined her and after you were writing the after incident report. Is that correct?
Yes.
So then you go to the next page, and each number that you see on the previous page now has a description of what the burns were that you observed on the body. Is that correct?
Yes, sir, that's correct.
Okay. When you were with her on the ground, did you do an assessment?
Yes, sir. What little bit I could. The lighting's not very well. She was wrapped up in the blanket, as I said. Pretty much looked at her and said, you know, we've got a significant amount of burns. We need to keep her warm. You know, at that point in time, we were unloading our stretcher, all our gear and everything, the burn sheets that we used for burn victims. And we placed her in that, wrapped her up in them, and got them in the truck, cut the heater on. Losing body heat's a big significant issue with people with burns like this, so we try to keep her as warm as possible with the burn sheets and the heater in the truck.
Okay, so who actually called for the helicopter?
I think I told Brad, I mean, as soon as we got there, I laid eyes on her, saw this was serious. I told Brad to call a helicopter. I believe he calls it on the radio, and then MedStat Dispatch handles it from there.
Okay. And then the firefighters are responsible for getting the information to the helicopter about where to go, is that correct?
Yes, sir. They typically set up the landing zone, and they know the local area the best.
When you got Jessica into the back of your ambulance, I believe you just testified that y'all pulled the gurney out, and what did you actually put on her at the scene before you put her into the back of the ambulance? I believe you said something about sterile blankets?
Yes, some burn sheets, yes, sir.
All right, what is that exactly? Help the jury understand what that is.
It's a sheet. It's just designed not to stick to burnt skin. It's also sterile. It means there's no germs and everything on it. It's nice and clean. And it also helps keep retained body heat as well.
And you put those on her, and then I would assume you put her on the gurney after that, and then
Yes,
put her
sir.
in the back of the ambulance?
Yes, sir.
All right, when you got into the back of the ambulance, were you talking to her?
Yes, sir. We were trying to ask her, you know, simple assessment questions, establish her mental status, things of that nature.
Right.
She was able to tell us her name. Anything.
How was describe her voice for me as you were attempting to talk with her?
Her voice was garbled whenever she was trying to talk to us. One can imagine she's probably inhaled a fair amount of hot heated gases, you know, during this whole burning process. There was soot in her airway as well whenever we looked in there. She could talk, but she had trouble enunciating certain syllables. It was real garbled whenever she spoke.
And did she in fact tell you her name?
Yeah, I remember clearly understanding Jessica. She had said Chambers, and I didn't understand it, but somebody else had asked her Chambers, and then she said yes. I remember that.
Okay, and then what about, did you recall Daniel Cole being in there?
Not specifically, no, sir.
In your ambulance?
I'm sure he was, but I don't specifically remember.
Okay, do you remember anybody asking her who did this to you?
Yes, several people asked her that.
Okay, and do you remember any response that she might have had?
She said Eric, or tried to say Eric or Derek or something to that effect with those syllables.
Okay. And what other life-saving treatments were you attempting to give her?
We attempted to, outside of keeping them warm, you need to give them fluids as well. I could not find a vein on her body to start a regular IV on her, so we moved on to intraosseous access, which is the IV through a bone, basically. We're unable to do that as well. I was unable to drill. We have a drill, and it was unable to penetrate her tibia when we tried that.
In her leg?
In her leg, yes, sir.
Okay. At some point in time, so when y'all were actually on the hill, I called up on the hill where the fire was, you were unable to get any fluids into her. You were only able to get the burn blanket on and get her ready to be transported. Is that correct?
I think, let me check my times.
Yeah,
make sure.
check your notes if you need to.
You're gonna need to speak up a little louder.
Yes, sir, I'm sorry, I apologize.
The jury's having a little trouble hearing you,
Okay.
sir. All right. They're a long way away from you.
Yes, sir. 40. Yes, sir, we tried the IO right before we transported, 2 minutes before.
And the IO is?
The intraosseous, the bone IV.
Okay. Eventually, you did transport her, is that correct?
Yes, sir.
And where did you transport her?
It was we ended up in the Shiloh Baptist Church parking lot. I believe it was 0.6 miles from where the scene was. I get a lot of feedback.
Was it six?
0.6 miles.
And what did you do upon your arrival at the landing zone?
At the landing zone, people were still questioning there. Somebody with the law enforcement was taking pictures. I think at that point, we were simply just awaiting the helicopter to get there. We were watching her airway. Another issue with burn victims is their airway will begin to swell. They'll have breathing problems, and we were making sure that was not occurring. We were just monitoring her airway and waiting on the helicopter.
Do your notes reflect what time the helicopter got there?
I don't think they do specifically, no, sir.
Okay. I believe Bradley testified it wasn't real long after y'all got there, the helicopter got there. Would you agree with that?
I agree with that. It wasn't a significant amount of time, no, sir.
What would be the protocols upon the helicopter arriving? Who actually takes control of the patient at the time the helicopter gets there?
I believe officially, as soon as the highest level of care there arrives, it's technically their patient from that point forward. When they arrive, they bring, their cardiac monitor, all their equipment. We're taking ours off, putting theirs on. I told them we were having trouble getting the IV access, and they had their IO, which was functional, and they were able to put in 2 IOs. And outside of that, once we did that, we put her on their cot and loaded her on our stretcher and put her in the aircraft, and they lifted.
Your Honor, tender the witness.
Cross.
Good afternoon, Mr.
Good afternoon,
Perkins.
ma'am.
You don't have any idea of what time the firefighters and other possible paramedics got to the scene before you got there?
Nothing official, not on my paperwork that I have. I just have the times that I got there, ma'am.
Yes. But based on the paperwork that you do have, you know that you didn't get there until about 8:29 or 8:30.
Yes, ma'am.
Okay. And if you will, you still have the report in your hand.
Yes, ma'am,
correct?
I do.
Okay. Of which you authored this particular report?
Yes, ma'am.
Correct? Okay. If you would please go to, I believe it would be the 3rd page. See where it says time of assessment?
Can you show me?
May I approach the witness, Your Honor? Okay.
Yes, ma'am. Yeah. Oh, okay, I see what you're talking about. Yes.
You see time of assessment?
Yes, ma'am.
Okay, so that would be 8:30.
Yes, ma'am.
Okay, so that means that would have been, that would have been the time that you assessed Jessica, correct?
Yes, ma'am.
Okay. If you would go down just a bit, you see where it says chest?
Yes, ma'am.
What does it say after that?
It says clear breath sounds left, clear breath sounds
Welcome back to the
right.
Law&Crime Network, everybody. This is Jesse Weber, and thanks for joining us. We are replaying clips in the Quinton Tellis case from 2017 out of Mississippi. Again, this is about the death of young 19-year-old Jessica Chambers, who was burned alive. Really, really horrific stuff. And what you're hearing is testimony in that case, and the reason we're playing it, and I keep mentioning it, is because we do anticipate in 2018 that Quinton Tellis will be retried in connection with the death of this young girl, because his first trial ended in a mistrial. A jury could not decide whether he was guilty or not guilty. They could not decide unanimously. And we want to understand, why did that happen? So we're replaying the entire case. Right now, I'm joined by former prosecutor and senior editor of here at lawandcrime.com, Ronn Blitzer. Ron, I want to talk about this Quinton Tellis case. Do you think it was really the fact that the first responders heard Jessica say an Eric or a Derek as the perpetrator of this crime, the reason we did not see a unanimous guilty verdict?
It's the only thing that I could really think of to explain it. I don't agree with people who would just pin everything on that, but when you have so much evidence against Tellus here, and then you counter that with the fact that Jessica Chambers said Eric, jurors could be confused. They could say, oh, well, she clearly said it was someone else.
Because you don't always get a victim statement like
right,
that.
Right, exactly. Like, you have the victim saying who did this to her. She didn't say Quinton, she didn't say Tellus. So jurors could say, well, there you go, it wasn't this guy. but she was in horrible shape. She had been severely burned, wasn't speaking clearly. She could have been trying to say Eric and was unable to. So, I mean, say Tellus and said Eric by mistake. So if you buy that she meant to say Tellus and physically couldn't, then her saying Eric wouldn't be a problem, but maybe it was for some jurors.
What about the argument that she was able to form other words? She was able to identify herself. She was able to identify that she was cold. Again, it's so not fair to say what she could say or not say. I mean, she suffered burns to over 93% of her body, and her mouth was charred and filled with soot. So it's not fair to say what she was able to say, and also what condition she was actually in. I mean, she just suffered this horrific trauma. So it's not fair, but is there something to say for the fact that she knew Quinton Tellis, she knew his last name, she could have said Quinton, she could have said Tellus, and Eric and Derek are really different from that?
Well, Eric is. Derek and Tellus aren't that different. If you're having some sort of speech impediment and you're trying to say Tellus and it comes out as Derek, that I can imagine. But it's such a rare situation where you have that kind of statement from a victim trying to identify the person who did this thing to her, and now you can't get any kind of clarification.
So the people that voted guilty, what do you think they really hinged upon? Was it the fact that Mr. Tellis was not so forthright with authorities, that he changed up his story, that his alibi didn't really work? What was it that they said, this guy definitely did it?
Well, it's all of that. When you have a suspect, a defendant, who's changing their story, that right away makes a person look guilty, even if they're not. You know, if you're lying to authorities, if you're giving one story and then saying something else afterwards, it really hurts your credibility and it makes you look like you're trying to hide something. On top of that, if he admits to having a sexual relationship with the victim here, admits to having, a 5-gallon drum of gasoline, and she was found burned alive, that doesn't look good for him.
And let's talk about the fact that the car, the actual car where she was found that was burned, the passenger seat where he said that they had sex that was reclined, it was just that. So his story kind of matched up to that. I mean, it placed him in the area with her at the time, right? And I think John Champion, the prosecutor in this case, really articulated well. He said, it's simply not feasible for Chambers to leave Tellis's company and then within 4 minutes get together with somebody else who killed her. Not feasible, or is it possible? What do you think?
I don't think it's feasible, but she said Eric did it.
You know what, Ron? It's so interesting with this case. There are people, we talk about it constantly, who 100% believe he had absolutely nothing to do with this. They think that Quinton Tellis is not the person who did this. And then there are people who say, he absolutely did it. I have rarely seen a case so split down the middle before. Have you seen that? You feel that same way about this case?
Yeah, I really thought that he was going to be found guilty during the first trial, just with so much evidence against him, placing him there, him admitting to certain things after changing his story. I really thought we were going to get a guilty verdict on this. And yeah, you have the Eric did it. But to me, that's clear. She was in serious physical condition. She had significant damage. She was also in shock mentally and emotionally. It's just happened to her. So the fact that she wasn't speaking clearly or wasn't able to pronounce something after taking that kind of damage isn't surprising to me. So it seemed pretty obvious to me that when people heard Eric or Derek, she was trying to say Tellus, but a lot of people apparently couldn't get around that.
You're a former prosecutor, okay? Did you ever have the possibility where it became a question of, did you rule out every other suspect? Did the authorities rule out every other suspect before you decide to charge a defendant? And here, I had an issue with it in the sense, what did it mean to fizzle out, all these other leads fizzled out? You went after every other Eric or Derek in the community, you went after every other suspect. Doesn't the law enforcement become judge and jury then, deciding someone is not guilty? You know what I mean?
No, I mean, that's what happens. You have to chase down every lead you can, and you go with where the evidence points. You're not going to charge every suspect in a case if you don't have probable cause, if you don't have reason to believe that they were the ones who did it. So she said Eric or Derek, and they could say, oh, well, we looked at other people, and nope, this is our guy. This was Quinton Tellis.
I mean, they had to. They had to look at every Eric and Derek.
Yeah.
And we're going to hear testimony probably later today where they talk about those leads that fizzled out. I think people, and if you look on our message boards, that was a big question. How do the investigators actually rule somebody out? Is it just alibi? Is it just interviewing them and you can tell that they're being truthful? What goes into that whole understanding, that whole process of ruling somebody out as a suspect?
It could be any of a number of things. It could be what you just mentioned, people coming off as credible, people having an airtight alibi, saying, nope, they were in this different place, and here are 5 people who were with him who can say that they were with him. It could be the evidence that specifically pointed to Quinton Tellis, when you can track phone locations and you could say, oh, they were together, they did this, he said this, he was changing his story, then he said this. And when you have that much evidence pointing towards one particular suspect and you don't have that regarding other suspects, then it's sort of a process of elimination sometimes. But I'm sure if they were looking at other suspects, they wanted to make sure, and those leads fizzled out, as you said, as they pointed out, and they were left with Quinton Tellis.
I want to tell you, this is what John Champion described as what happened. So he said after they had sex, he submits, even though there's really no evidence to corroborate this, that Tellis strangled Miss Chambers. She was apparently knocked unconscious. He said that he believes after that Tellis borrowed his sister's car, got his gas can, drove to the scene, poured gas in the car, lit her on fire, then drove to Batesville, Mississippi, to purchase the Green Dot cash card that he was planning to send to his girlfriend in Louisiana. Does that time frame seem off to you, all this activity? Or was it really these different locations, the gas station, his house, where this fire took place, where he got the Green Dot? Isn't it possible that he could have gone to all these locations? Or is it just you're really speculating kind of hard that he could do all these things in such a short amount of time?
It's certainly possible, but again, they're not trying to prove everything that he may have done in the time before and after this. They're trying to prove that he committed this act. And I think that if you look at all of the evidence and you look at things that he has said and you look at the condition she was in and where she was and where he was, that there's enough evidence there.
What do you make of these alibi texts that John Champion had said that at 7:42, Mr. Tellis had texted Chambers something along the lines of, hey, honey, I can't be with you tonight. My girl's coming up. He said that was an alibi text used to throw police off. Interesting time frame to text her that after he just allegedly saw her, right?
Yeah, that could be an alibi text. It could also be an excuse for why he wasn't around when he was murdering someone or trying to kill someone.
Or is this a guy that was fooling around? He was cheating and he didn't want to get caught. I mean, we've seen cases like that before where guilty parties are guilty not in the sense that they committed a crime, but they cheated or they were fooling around with somebody that they shouldn't have been fooling around with. How much is it possible that that's what this is, and how much is it the possibility that he's covering up a murder?
Yeah, you could argue either way on that. If you're the prosecution, you're going to say he's trying to cover up a murder. If you're the defense, you're going to say he's trying to cover up an affair. That could go either way. If you're a juror and you're believing one story or another, then you could use that piece of evidence to support whatever you're already believing.
Ron, I'm going to ask you the $1 million question here, okay? If this case is retried in 2018 and Quinton Tellis is put back on trial and John Champion is prosecuting this case again, what are the tactics that the prosecution has to change to really get that guilty verdict? Again, you'll have a different jury, okay? They'll be hearing it for the first time, or you hope that they will be hearing it for the first time. Do they change their strategy? Does the defense change their strategy? What happens?
If I'm the prosecutor, if I'm Mr. Champion, I'm going to try and really go after this Eric defense, and you're going to see if you can get medical experts to show that, yeah, someone in Jessica Chambers' condition may not have been able to say Tellus and it could have come out as Eric. I would really want to get testimony that supports that.
Okay, and what is the thing that really, for the prosecution, I guess, do they have to change their strategy a little bit? I mean, I feel like they might have to. They might have to say something to explain those kind of iffy facts, like the strangulation and running all around. I think they might have to tighten that up a bit, no?
Yeah, if they're, for certain weak parts of their case, you either try and tighten them up or you try to get rid of them altogether and just focus on your strengths and leave the weaknesses alone. But at the same time, they may think, no, there was nothing wrong with our strategy. We just got a bad beat. It was, one or two or however many jurors who didn't buy it. We're going to stick with what, we had and hope for the best with a new jury, because it wasn't a not guilty verdict. So all they have to do in their minds could be just push the strengths of their case a little bit more and the jury will rule in their favor.
Is it not possible, if this is retried, we could see another mistrial? And we've seen this before in the Ray Tenson case. He was tried twice and then they just dropped the charges. If it is declared a mistrial, because we keep talking about this split, I mean, you can look on our message boards, you could talk to anybody who knows about this case, they're split. Some people think he absolutely did it, some people think he had nothing to do with it. If there is a split, if there is a mistrial, would they charge him again?
They could.
They could, but would they?
Would they? Maybe, maybe not.
It's expensive. You try in person again.
We've seen cases where you have two mistrials in a row, prosecutors say they're going to go for a third, and then they end up cutting a deal. So if you have a second mistrial, Tellus may accept a plea after that.
It's interesting to follow. Really tragic case. We're showing pictures of this young girl, just the brutality of what she had to go through. That's what's the difficult part. This is the case that's really, I think that's what's so haunting about it, is to think about what she went through. And we're playing you replays of this case to hear about what she went through. And I know it's difficult to hear, but it's important to hear. So we're going to replay you some more clips. I want to continue showing you the testimony. And when we come back, hopefully, we will have our appearance, our feed in the Arizona courtroom in the case of Thomas Robinson, that judge who's in some pretty sticky water for stabbing his wife, or allegedly stabbing his wife. So that we expect a pretrial hearing any moment. As soon as we do have a feed, we'll make sure to go to it. In the meantime, I do want to play you this clip from the Jessica Chambers case.